Next. A very good afternoon to one and all present online and offline. Welcome to the 10th study circle meeting of the GSTPAM for the year 24-25. We have a very important topic today which affects our day-to-day practice as well. The recent case laws have had a lot of impact in the way we will be dealing with certain transactions, and therefore we requested our esteemed speaker Ratan sir for taking these specific judgments. The judgments have already been circulated amongst everyone along with a small gist, so that everyone is aware of uh, of the uh, the judgment per se and what it holds. But we will go in more in depth with today's session. Before we begin, I request President sir. He wishes to say something. President.
Good afternoon. Before start, this is the first public meeting after Pahalgam. So we have lost 26 lives, innocent lives. And that's why I request everybody to stand for 1 minute to observe silence. Thank you. Om Shanti.
Before we begin, I request Chairman LNR Committee Sujata Madam, who is present online, to say a few words. Madam.
Thank you, Umang. Am I audible?
Yes, madam.
Yeah. I welcome Shri Ratan Samal sir. And today's topic is very, very interesting. I'm sorry that I could not attend it physically because I was in Mazgaon for some time, but I finished very early and I had some other work also to do. So I could not, stay.
आपने म्यूट किया उनको.
Am I audible now?
Yeah.
So I welcome Shri Ratan Samal sir. I've gone through the number of judgments he is going to speak about. I think the ratios laid down by all these judgments are quite important for all of us. I think GST law is coming of an age now, and many intricate issues, or rather a basic fundamental issues, are being now discussed in all these judgments. And therefore, today's meeting is going to be very important for all those who are practicing in GST. Now, without wasting further time, I think we should allow today's speaker to, start his deliberation on the judgments on the topic today. Thank you so much.
Thank you. Thank you, madam. I'd request Harish Bhai to quickly introduce our today's speaker before we hand over the proceedings to him. Harish Bhai.
Thank you. Our today's speaker actually needs no introduction. His name is Sri Ratan Samal. The name itself says he is a gem. So he is really a gem of a person as far as I am personally. So, but this is a protocol and we have to introduce him. So let me do the formalities for the same. Advocate Ratan Samal was born and brought up in the state of Odisha. He graduated as a commerce student in the year 1986. He completed his company secretary course and then proceeded to pursue law. He completed his law LLB degree from Mumbai University, Ruparel College, in the year 1993. He also pursued LLM from Mumbai University in constitutional law. He was a part-time visiting professor at Bhubaneswar College as well as AC College of Management Studies in his early days of practice. Mr. Samal used to provide training to inspectors, class 1 and class 2 officers of the sales tax department from 1997 to 2002. He used to appear as a special counsel for the state of Maharashtra before Honorable Maharashtra Sales Tax Tribunal in specially assigned matters from the year 1997 to 2005. Mr. Ratan Samal's area of practice includes both direct and indirect tax matters. He regularly appears before the Maharashtra Sales Tax Tribunal, Income Tax Appellate Tribunal, and Bombay High Court. He is practicing as an advocate since last 25 years. He has achieved a number of awards for his outstanding performances in lectures, seminars, write-ups, etc. He has served as the president of Maharashtra Sales Tax Tribunal Bar from the year 2016-17 to 2017-18. He has filed various petitions for the enhancement of emoluments and allowances of the judges before Bombay High Court, development of efficient functioning of sales tax tribunal, and in some educational matters. Mr. Samal delivers lectures and seminars regularly on the recently enacted Goods and Service Tax Act with the intention of educating chartered accountants, lawyers, practitioners, and businessmen to deal with the complexity of the issues emanating in GST. With this, I introduce before all of you our today's esteemed speaker, Shri Ratan Samal. But before he starts his deliberation, I would request our senior member, C.A. Deepak Thakkar sir, to present a memento to our esteemed speaker, Shri Ratan Samal sir. Thank you, Deepak sir. Over to Oman.
Sir, I request you to take charge of the session.
Either side. Respected President, Chairman of the LNR Committee, Sujata Madam, our other office bearer, it's a great privilege to me, to address once again on very important topic, that is recent decisions. I will try to make it as much as simpler along with the statutory provisions and how to overcome, and thereafter the practical implications, how we should take into account during our day-to-day course of practice. Now, without wasting much time, let us directly go to the issue and topic. The first and foremost important judgment today's topic is the judgment of Kerala High Court in the matter of Indian Medical Association Kerala versus the Union and the states. Now, in this judgment, brief facts of the matter is that Indian Medical Association, an association for, they provide different type of services to their members and their respective families also. And for that purpose, various schemes were implemented, which is called Hospital Protection Scheme, Kerala Health Scheme, Mutual Benefit Scheme, Pension Scheme. These schemes are framed and incorporated in their bylaws. So all these schemes in nutshell is for the benefit of their members or their family members. And in some of the schemes also, they gave aid to the needy patients also. So these are the schemes brought, and for that purpose they need money. So by way of a contribution fees they have collected from the members. Authority is of the opinion that these fees collected are subject matter of levy of tax under the GST law. On the other hand, the association is of the stand and opinion that no, it is not subject matter of levy of tax. From there, the matter went to a single judge of the Kerala High Court, and single judge has, after having, a detailed hearing, the court has observed that the new section under the under the purview of scope of supply under section 7, as you know, because I'm not going to touch entire legal provisions, you know that scope of supply is the heart of the matter. Section 9 is the brain, is the charging provision. We should not forget before coming to this judgment. And in the supply is subject matter of levy of tax. So in the scope of supply under section 7, in 2021, they brought an amendment. That is 7(1)AA, they have added it. In that amendment, they said that this supply of services means services rendered by, I'm very sorry, it is not a supply, services rendered by the association to their members against a contribution fee, whether subject matter of levy of tax was not clear in section 7. So they brought an amendment and they said that any supply to their members, either goods or services, then in such circumstances that amounts to a supply for the purpose of section 7. And further in the explanation, the amendment was brought from 2021, saying that whether it is an incorporated society, incorporated persons or unincorporated person, whether it is a society, body of persons, club, association of persons, whatever name called, whenever a contribution is collected or a fee is collected or in any other name it is collected, that same amount is that amount is subject matter of levy of tax, and it will fall under the parameter of scope of supply. In that way, they have explained by way of explanation. And further, they said that although there are several judgments are came, they are in mind that Calcutta Club's case. So, notwithstanding anything, any judgments or any other laws, this provision will supersede. So, a non-obstainable clause they brought in the amendment. Because of that, these litigations came up, and the single judge in the Kerala High Court has held, saying that yes, it is valid law. That amendment which was brought is in consonance with the constitution mechanism, and it is not ultra-virus to the constitution, even not intra-virus to the scheme of that. So it is valid. But the single judge has observed that no, it is applicable prospectively, even though the legislature has brought that amendment with effective from the right from the inception, that is July 17. But single judge has held that no, when a subject matter of levy is a subject and it is a substantive provision, then in such circumstances, it must be always a prospective. So they hold that, I mean, single judge hold that prospectively from 2021, all such transactions of contribution of fee and in the similar nature collected from the members will be subject matter levy. Matter went to division bench. Now the division bench has analyzed all the things. Now, see, the issue of ultra-virus to the constitution is challenged, as well as intra-virus to the statute itself. See, you must have aware that ultra-virus and ultra-virus means which is contrary to the constitution mechanism, a constitution provision. Intra-virus means the scheme of the act says something and the rule or circular or notification says otherwise, then it amounts to an intra-virus. So both the things has been challenged. Now in this context, court has minutely observed. So we should not forget our mother law, that is constitution. What the constitution says, see, it's the most important decision, although it is a Kerala High Court, how it has to have a binding effect even in Bombay, I will come in the latter course. So when amendment was brought in order to bring GST legislation, most important amendment which was brought is amongst other 269A, all these things. One definition clause is brought under Article 366. Article 366, they have incorporated after clause 12, clause 12A. That is the heart of this matter. Now, how it reads? Once you understand, then the judgment will be understood. What the article says, Article 366, which is an interpretation clause, and in that, 12A has been brought. 12A amended and brought. How it reads, kindly see. That is the heart of this matter. Goods and service tax. Goods and service tax means any tax on supply of goods, comma, or services, or both. So the language used, further it says that except the tax on supply of alcoholic liquor and all, we are not concerned with that. Goods and services tax means any tax on supply of goods, comma, or service. Now the questions arises here, whether the constitution empowers that the term which is used, goods and service tax, means service. When the services is rendered to themselves, whether it tantamounts to a services in the eye of constitution or not, that is the question. If services rendered for themselves, a club or association of person or a society or a body of person, when themselves render services, members are not different from the society, members are not different from the clubs. You brought an explanation in section 7, 1AA, saying that there are two different persons. You are saying that. Now the question arises whether this amendment which is brought in consonance with this Article 366 clause 12A or not. This question arises. If it is in consonance, then it is not ultra-virus. If it is beyond, then it amounts to ultra-virus. Analyzing after various decisions, including the Calcutta Club's decision, Supreme Courts, this division bench has held that how we know under the constitution so far as the supply of goods or service. See, till date, even I was of the opinion that supply of goods, I was reading this section 9 of the GST Act or section 7 or this 363/29A. Before this judgment, I was reading tax on supply of goods or tax on supply of services. I was reading like that. Court said, no, you don't read like this. Court says supply of goods is an independent element, then or, then service, then or both, either goods or services. So independently you read. So far as the supply of goods is concerned, Calcutta clubs matter, they hold for the purpose of service tax or for the purpose of this constitutional amendment 46 constitutional amendment, which brought clause 29A, you know, all works contract, lease and everything brought in that this association of persons selling to their members, all these things came. There they have told about the goods. Now, when you talks about the services, so far services is concerned, there must be two different persons must be there. Otherwise, you come with a definition of service saying that even these services by themselves, to themselves also amounts to a services. In your definition of the services, it doesn't shows like that. So you have not defined the term services so as to incorporate services made by a persons to themselves tantamount to services. You have not amended, number one. Till date, under the constitution mechanism, whether it is a sale of goods or providing of services under the Finance Act earlier, there were two different persons were there. Always, till date, wherever, whatever the matters taken up to Supreme Court has analyzed and said that there must be two competent persons. Keeping in mind the legislature in their wisdom, they said the provider of service in our GST legislation, in number of places you will find that provider of services and recipient of the service. So there must be two different persons. One is a provider of services and other one is a recipient of services. And keeping in mind this aspect only, in various machinery provisions, secondary legislations, they brought that provider of services, supplier of services, recipient of services, all these terms. At the same time, you are not amending the term services. And canton of judgments, including constitutional benches decisions, are shows that all these supply of goods earlier under the local legislations, two competent persons were there always. And similarly, in respect of services, also two different persons were there. You are not amending even Article 366 clause this 12A. So you are not amending that one. If constitutional amendment is not made, then what the constitution is understanding in respect of services, you have to adapt it. So constitution is understanding so far as the services is concerned, two persons, two different persons till date. So what the court has analyzed and asked, first you amend your constitution in Article 366 in 12A, saying otherwise whatever the meaning adopted for the purpose of services or supply of goods will be deemed to be treated as a supply made by one person and receipt is another person's. So first you amend your constitution. Unless you amend the constitution, you have no power because your mother has granted power under article in the constitution. Then they say GST means supply of goods or services or both. So the understanding is services means not to self. So if your mother says so, how in a secondary provisions by way of section 7, you enlarging the definition of scope of supply, you are saying that the scope of supply will be extended even to themselves. अभी दीपक भाई को मैं मजाक से बोल रहा हूं. And when I am speaking to myself, it is an awkward positions. कोई इधर नहीं अगर है, I am speaking online as if I am speaking to myself. So that situation, I cannot deliver what I want. But wherever opposites are physical presence are there, I can deliver a lot. Like that only. This aspect is also. So giving to yourself only. And rendering services to oneself doesn't falls within the parameter of the constitution provision under mainly 366 bracket 12A. So 12A authorizes you. And the understanding again at the cost of repetition is that 12A services or say supply of goods indicates two competent persons till date. So now you are bringing under section 7 saying that the scope of supply is extended. Even you are not enlarging the definition, I mean the levy provision of section 9 also, you are not analyzing, nor you are amending the definition of section 7. Then in such circumstances, both it ultra-viruses the constitution as well as intra-viruses to your levy provision. Hence, in this judgment, court has said that it is clearly an ultra-virus. Although after 46th amendment, Calcutta Club decision came, there also they have analyzed all these things. They said that you first amend your constitution, no, so that constitution will empower you to levy tax, because the source of power is from the constitution itself. In the definition of services also, you are not saying, even for the sake of argument, though court has not gone to that extent. Suppose we are amending the definition of services also and incorporating in section 9 also, whether constitution empowers. So amendment of constitution in 366(12)(a) is must, which empowers. So levy of GST on the sale of goods or services, in the bracket you may say whether the sale of goods, supply of goods or services to themselves or to the branch or to outsiders. Such sort is not there. So the normal connotations which the court has analyzed earlier will hold good. So till that point of time, the courts has said that whether it is a supply of goods or whether it is a services, there are two independent parties. That's why, keeping in mind the legislature in their machinery provisions analyzed and brought such sort of mechanism saying that service recipient and service provider, all these two aspects repeatedly they had said. Hence, merely amending section 7 and bringing in with the main clause, this particular clause saying that services to yourself is tantamount to a services which is levy tax, which can be imposed tax, is not holds good. So they declare it is an ultra-virus. Once it is declared as ultra-virus, then no need to discuss about the applicability effect, whether it will come into from the date of amendment to 2021, or it will come from the retrospective, no need. Once they have declared an ultra virus, it remains ultra virus and no levy is permissible. In that way, they have analyzed and interpreted various aspects and hold that it is an ultra virus. But the single judge, when decided, he has upheld the provision, but so far the effect of that is given prospect, because looking to the substantive. So to that extent, suppose tomorrow Supreme Court upholds the view of a single judge, then in circumstances, and set aside the division bench decisions, then in such circumstances that periodicity has an impact. Okay, so we should keep in mind. Now the question arises, very crucial and important question. Kerala High Court decision, whether it is a binding on us. We are sitting in Mumbai, Maharashtra. See, under the rule of the precedent, because every time this question will come to our mind, always, while analyzing and while filing the return and everything. That is given by Kerala High Court. How far it is binding on us? In the constitutional setup, in the rule of precedents, it is a developed by making of a law. There is no law as such like precedents under the constitution. So it is developed, self-made. I mean, law is developed, evolved by way of various decisions. In the scheme, they said that normally, if one high court decision is given in one particular state on a particular subject, if the same subject is under dispute in another high court, normally the other high court should follow in order to maintain the consistency. It is having a persuasive value. Okay, it is having a persuasive value. So this should adapt unless a contrary clear opinion is there from the second high court. But here when question of constitutionality comes, question of ultra-virus or intra-viruses arises, then in circumstances it is binding. I'll give a very unique judgment, which is most important whenever, whether we are arguing before tribunals, high courts, or before the authorities. This judgment is Kusum Ingots and Alloys Limited. Kindly note it because it's very important, and one paragraph they have analyzed. The issues were different. Kusum Ingots and Alloys Limited versus Union of India. Repetition. Kusum Ingots and Alloys Limited versus Union of India. It is the judgment of 28 April 2004. 28 April 2004. Citation. Six SCC, 6 Supreme Court cases, 254. In the 6th volume of SCC, you'll find at page 254, this Kusum Ingots. It's most important how the court has analyzed and said about this aspect, binding precedent of the other high court's decision. I am reading the relevant paragraph. The court must have to requisite territorial jurisdiction. An order passed on a writ petition quashing the constitutionality of Parliamentary Act, repetition. An order passed on a writ petition quashing the constitutionality of a Parliamentary Act, whether interim or final, whether it is an interim order or a final order, if it is a central legislation, that is Parliamentary Act means central legislation, under a writ jurisdiction, If court passes an order, keeping in view the position of contained in clause 2 of Article 226, Article 226, subsection 2, keeping in mind, will have an effect throughout the territory of India. It has an effect throughout the territory of India. This is the language of the court. In Kusum, in God's and alone. So the persuasive value theory, the theory of persuasive value of other high courts decision will be applicable other than the challenges where constitutional validity is not normal interpretations when comes on a particular subject. Then if a court takes a decision, then in such circumstances the other state may follow or may not follow. It as having a persuasive value. But wherever constitutionality is under question, like ultra-vires, intra-vires, then in such circumstances, it has a binding effect throughout the territory of India. That's what in Kusum in God's. There are several other judgments. And further, in Kusum in God's, it is an obitra dicta. So it is not a ratio. Whatever the question you ask to the Supreme Court and Supreme Court gives in return, that is called ratio descendenda. But wherever passing observations are made, then it is called obitra dicta. So that passing observations made in the Kusum in God's and alloys, whether it is a binding precedent, the questions again comes. Yes, answer is yes. Supreme Court in number of judgments, they said that even a obitra dicta of a Supreme Court is a binding precedent to other high courts and other authorities. That is various judgment like Tera Chinnappa Reddy versus Government of Andhra Pradesh. Tera Chinnappa Reddy versus Government of Andhra Pradesh. It is a judgment of 2013 Supreme Court. You know Dharmendra Jani, that is also there. 2021, Dharmendra Jani versus Union of India. They laid down these principles that other courts' decisions are having only persuasive value in other matters. Then Chinteswar Steel Private Limited, Union of India, 2013, Chinteswar. So ultimately, what I want to express is that Kerala High Court has struck down on the base of validity, constitutional validity. What this is, you have not amended your constitution in 366, 12A, nor the parallel provisions under the constitution, nor you are amending the definition of services in the GST law, nor the levy provision section 9. You are simply bringing an explanatory nature section, which is section 7, what is the scope of supply, and there you are amending, therefore it is an alteration to the constitution. Hence, a services made by a society or a club or association of persons to their respective members. I'm repeating services. I'm not talking about the goods. The judgment is not about the goods, services. Collecting the subscription fees is not subject matter of levy. Applying the judgments in the matter of Kusum ingots and alloy, the obitra which has been given, then even in Bombay, even in Maharashtra, that holds good, that Kerala High Court, until it is struck down by the Supreme. So undoubtedly the matter is taken to Supreme Court. But very carefully they have analyzed this decision. I have gone through very minutely, observed various decisions, constitutional judges, benches decision and everything, and concluded. So now, practical point of view, we should accept this judgment and accordingly in our day-to-day work incorporate and advise. Sir, I'm pointing out, after every judgment is concluded, you can raise your queries so that we will address it and then immediately jump to another. Deepak bhai.
Aspects I want to ask you.
Yes, sir.
Why not for goods this applies? How do you read that? First, second one about society and members in our housing societies and all that. How they should adopt this judgment or wait or what? Second, and then third one, will this judgment also impact the definition of the term distinct person in GST law? So that branch to HO2 branch is also supply of service. That he also
Yes.
touched and affected.
So first answer, Deepak bhai has raised, Deepak Thakkar sir has raised a query saying that how far it has a applicability or not applicable so far as the supply of goods is concerned. Okay. In respect of the supply of goods is concerned, keeping aside the Calcutta Club's decision, that is again on the service tax.
If I recall, even there they said VAT was not applicable.
They said Obitra also there VAT is not applicable. If you keep in mind that Supreme Court's decision on that, which is pre-GST regime, that was also argument here in Kerala that it was under Bombay, Calcutta General Sales Tax Act. So it is how far it is applicable. Under Article 29, under 366 Clause 29A by the 46th Constitution Amendment was made. Please keep in mind. 46th Constitution Amendment क्यों आया है? Deeming sales के लिए आया. Deeming sales means sale of goods. For that purpose, it has brought. Okay. So even under that also, Calcutta Club, how they went, they said that even under that also, they never discussed or amendment provisions were not made so far 329A is concerned. They have not come with two different, always sale is understood two competent persons. Because sale is defined in that also, under the scheme, constitution scheme. So sale as understood under the Sale of Goods Act or on the constitution mechanism is to be understood. Therefore, even after 46th constitutional amendment, unless you bring a clear amendment in the constitution transferring that, even if there is no two competent persons, then also it tantamount to sale. Therefore, we are holding, that was the observation in Calcutta Club's mind. Therefore, they said that these two competent persons were not there in the anywhere. Therefore, that is not hold good. The same analogy can be applied, but the question was here in relation to service, they answered accordingly.
Sir, couple of questions. Each has
First, Deepak bhai, second is raised.
Second, society,
Society and to their members. Already they have analyzed, since they are not two different persons under their constitution itself, under the law which is governing by them. The law which are governing, like Societies Act, in the case of an association persons, different act is there, Societies Act and all these things. So there it says not two different persons, but themselves renders and profit also they enjoy. Apply. Even if it is a commercial society, doesn't make any difference. Once you say it is a society, it is a club or body of persons, to their members only, unless you amend the constitution, or even if you amend in the definition of the services or in section 9, then also it not suffice. Yes. So in the constitution scheme, and distinct persons under the branch.
and if they are in different states or having different GST numbers, same scheme.
If they bring say levy provisions on that, that also holds not good. If you analyze these aspects. So two different persons. So doctrine of mutuality, the concept is there, which was well established in the Calcutta Club, having the equal force unless you amend the constitution. So what is needed, but most important is amendment. So therefore it is an ultra virus, and once it is an ultra virus, it is applicable throughout the territory of India in view of this Kusum judgments.
So,
Yeah.
Just what's the question basically, what is the position of societies today who have registered themselves? That I give you answer. So what do they do now? Do they apply for cancellation? And I'll add, do I ask for refund?
Ask for that. I suggest not to cancel that one because the matter is still sub judice before Supreme Court until a concrete answer comes from Supreme Court. Better ask refund and agitate, and wherever the payments are made, make ad hoc payments, not as a payments. Yes, sir. Our association also, whenever बिल्कुल अपना वो members का subscriptions अगर वगैरह सब ले रहे हैं, wherever it is also applicable, you have to take into. Okay? Any other?
Last. Can builder say that in such time that is sold under construction for prospective buyer, it is construction for himself, self-service and not liable?
वो नहीं है, वो different context है. We are talking about doctrine of mutuality. We are talking about two persons theory or supplying to themselves. We are asking about. Something is coming here. Because I am not well versed with all this.
Basically, before I sell,
Huh?
before any flat is sold, till the time I am constructing, then I say I am constructing for myself. With that logic is, I think that's the question.
No, here see, a person, see, kindly bear with me, a person other than individual, the term person, in the scope of supply of definitions, they excludes individuals. Okay. If an individual constructing themselves, it doesn't matter because even the scope of supply doesn't speak about that. What this speaks about, it is a society, body of persons and club and all this. Hope I have clarified the issue in a simple manner and the judgment language also very clean and clear in this respect. So now, this matter is taken up. Yes, sir. Tell me, please. And that third question I answer. Equally hold goods. Equally holds goods. Okay. Yes. Unless you amend the constitution.
We are litigating, like you suggested.
Under protest, yeah.
Also needs to be defended.
Yes, it's to be taken care. I am coming in the next immediately in the Bombay High Court decision. So not to worry. Our second important judgment is of our own High Court, Bombay High Court, L&T IHI Consortium versus Union of India. I have circulated earlier the citation and everything. See, in this case, brief facts of the matter is that L&T entered into a contract with MMRDA. You know that Mumbai Trans Harbour Link project. So there, they said, I mean, they have received an advance amount. They received advance amount. Who L&T received from MMRDA. Advances received and declared in the return. And tax has been discharged as per section 13. 13 is a time of supply of services. So under the time of supply of services, as you know, whichever earlier arises out of these three contingencies is mentioned. Payment received, invoices raised, made a provisions in your books of accounts, whichever is earlier. Mainly these three contingencies. Others are there corollary. So advances are received and paid looking to the time of supply. Assessing officer of the view, department is of the view that, and he has claimed also ITC, input tax credits, claimed input tax credit, whoever in the scheme of that. They said on the advances tax is paid, actual receipt of service of goods, services or goods is not there, which is one of the condition under section 16. Section 16 lays down certain conditions in order to be eligible to claim ITC. Okay. One of the condition is that actual receipt of the service or the actual receipt of the goods. So when advances, say in the month of March, for example, I don't know which month that is. Month of March you have received. Are you eligible for a ITC in that year? That question came. So analyzing this section 16, revenue is of the opinion that actual receipt of the goods or services is not there. Therefore, availability of ITC doesn't come. So disallowing ITC. Nor I am going to grant any refund, whatever them. So the validity is challenged. The validity challenged, saying that this advances received for appropriate analyzing this, I have to refer to sections again, scope of supply. See, scope of supply is the heart, when section 9 is the brain. So in the scope of supply, the wording is, kindly bear with me and listen carefully. All forms of supply of goods or services are both, such as sale, transfer, barter, exchange, license, rental, lease, disposal made, or agree to be made. So the supply of goods or services, whether made or agreed to be made, will fall under section 7(1)(a). So the contention या argument on behalf of L&T was this agreed to be made, which is not consonance with section 9 as well as not in consonance with the constitution provision. The constitution directs, as I read in earlier decision 366(12)(a), what it says, supply of goods or services are both is subject matter of legal tax. So supply of goods or services. So unless supply of goods actually is there, you cannot impose tax. So that was the argument. So agreed to be made to the extent of supply made, okay. Agreed to be made, it suffers lacuna. It is not in consonance with the constitution, nor your section 9 says. For convenience, I am reading section 9 also. भूल जाते बार बार ना हम भी, मैं भी भूल जाता हूँ, इसलिए वो सेक्शन 9 को रेफर करना पड़ता है. ये दो हार्ट ऑफ द सेक्शन एंड ब्रेन ऑफ द सेक्शन. सेक्शन 9 says there shall be levied a tax called as GST or intrastate supply of goods or services. So agreed to be supply of goods or services, whether falling under section 9? Answer is no. Similarly, read with 366(12)(a), supply of goods or services is not there. When it is made, then it is taxable. Agreed to be made is not there. To that extent, it is ultra virus or intra virus. That was the argument. First argument. So court has analyzed various aspects again, but they said no. Even if agreed to be made for future supply is subject matter of levy of tax. So they hold up the validity of this phrase. So whether it is correct or not, I am not the right person to address against the Bombay. I can comment on that. When Kerala High Court, if you look, Kerala High Court says that your mother constitution should say so. Your section 9 should say so. Your definition of services should say, then only you are authorized. If you keep in mind that aspect, then to that extent, this is also not valid. Your mother is not saying so. So in Supreme Court now again, we will adjudicate. But as on today, Bombay High Court is there. It is binding on us. So to that extent, even agree to be made, advance received is also subject matter of levy. Now second question. Second question arises, eligibility of ITC. Officer is of the view that actual receipt of goods or services as per 16(2) clause B is not there. Therefore, I am not going to grant you ITC. And it is a corollary. Even a voucher is deemed to be treated as a tax invoices that court has held subsequently, because your machinery provision says invoices or vouchers recognizes in that way. Here the language is used. Subsection 2 of section 16, I am reading for your convenience, which was interpreted by Bombay High Court. It starts with non-ostensible clause. Notwithstanding anything contained in this section, no registered person shall be entitled to credit of an input tax in respect of any supply of goods or services both him, unless he is in possession of tax invoice, debit notes issued by the supplier, registered under such tax payment documents as may be prescribed. No, I'm sorry. Subsection 1, I'm very sorry. Subsection 1, 16(1). How it says, every registered person shall use, what is used as shall, subject to such conditions and restrictions as may be prescribed and in any manner specified in section 49, be entitled to take a credit of ITC on any supply of goods or services or both to him which are used or intended to be used. So harping is whether it is actually used or intended to be used. So here, supply, if it is treated as advances as a supply and subject matter of levy of tax, and actual supply of services which are intended to be made in future also eligible to take ITC. So court said, see your language, and you are making a contradictory in clause B. So it is an intra-virus. You yourself is debating the views of earlier provision. Subsection 1 says, shall entitled. In clause B, you are coming under subsection 2, unless he received the goods or services. So this intended to be supply, intended to supply makes a perfect to be eligible to claim, I mean, ITC. In that way, they have directed that you grant ITC. So again, questions arise. Now, advance is subject matter of levy tax. So for Maharashtra is concerned, we agree and we are bound by that judgment. Is subject advances are subject matter of tax, and it is not treated ultra virus or intra virus. But at the same time, you are eligible to claim it. I think I have justified this. Advances. Complaint. So it should not be denied. Actually, goods received. So both अच्छी बात हो गया ये in this interpretation. Now we think where a suspicious hawala dealers actually received or not. ये context में भी हमको थोड़ा सोचना पड़ेगा practicality. Future में दे देंगे goods. Okay. इसमें any questions, sir? You came across? You have to once you read minutely, keeping in mind all these aspects, several things are coming. No questions. I think hmm.
Charge interest on advance till adjustment against invoice and supplier book said amount as loan. Then what will be the position of tax on advance or loan on loan?
No. See, in the agreement in L&T's judgment, good, appreciated this question. In L&T's judgment, the agreement itself says that in order to start the project, you will receive advances. So the agreement itself says that for the future supply of goods or services, you will get it advances. Whereas if the agreement itself says no supply of goods or services, it is separately a different loan transaction for which you are receiving advances, nothing to do with the supply of goods or services, then the question of invoking the GST law doesn't arise. Okay. Now please come to, because हम खत्म नहीं कर पाएंगे उमंग otherwise. Your query. Yes.
3 or 4, and then we can have another, if you want 3, we can have another session.
Oh,
Part 2.
Because sir, honestly,
4 o'clock ही है.
we have
Goa. So rushing करेंगे. We will rush it. Yes, Goa. Now Goa High Court's, I mean Bombay High Court's Goa bench decision. Here the question came up. A so-cause notice was issued to the Goa University, directing them you pay tax on the FLSN fees. So they grant to the colleges various kind of facilities against which the FLSN fees is collected. How they are going to conduct the course, then conduct the exam, then declare the result. All these things are there for all colleges. So they collect an FLSN fee. So so-cause notice is received saying that this FLSN fees is subject matter of levy of tax. Then the matter went to court. Now, argument on behalf of that we are not running any business. First. So it should be in the course of business. Unless it is in the course of business, I am not falling within the parameter of section 7 in the scope of supply. First argument. So it is not in the course of the business. And for the public at large, we are giving all these education facilities. In turn, it is a public utility. Therefore, we are not falling within the parameter of scope of supply. That's their argument. Then after analyzing these notifications, उसमें notifications बहुत सारे हैं. Analyzing this scope of supply and everything. Then, and for unfortunately, on the basis of this ITR income tax report, financial statements, they dragged to this university that you have to pay tax. Your financial report, your balance sheet shows that this much you have received against FLSN fees, this much against you have received all these things. Then court has analyzed these exemption notifications, which was declared in 28 June 2017. Exemption notification है अपना classification. In that 66 number, in the exemption notification, by an educational institution to its students, faculty, and staff. First exemption. By an educational institution to its students, faculty, and staff exempted from tax. Then to an education institution by way of transportation, catering, all these things. Then third, services relating to admissions to or conduct of examination on by such institution. That is most important. So whether the university themselves directs that admissions or conduct examination, or through somebody, a parent institution and colleges, it doesn't make any differences because it is not clarified. So keeping in mind this aspect, they say that it is an education services undoubtedly, but exempted from tax. All university affiliated are providing, colleges are providing this admission, conducting of examination and providing services. आपके लिए applicable हो जाएगा दीपक भाई? ये हम कौन सा लॉ कॉलेज MNLU के साथ मिलके कर रहा है. So the same thing will apply, Vinod ji. So if you read minutely this, whether you yourself as conducting by NLU or through like institution like sales tax, imparting an educations, it also and conducting exam and giving certificate will be qualified under the exam. So you can take the benefit of that. So fees lega, Vinod bhai. I'm one of the faculty there. Our existing. Radhika Agrawal is the most important decision of the Supreme Court. Next judgment, 150 GSTR 120 on Radhika Agrawal versus Union of India and others. Power of arrest by the central agencies. Most important decision. Power of arrest कहाँ से आ रहा है? When you commit an offense. How the language is worded in section 132. See. Yes, offense committed. Allegation of offense is not offense committed. So that the distinction is there. You please read 132, how it is worded carefully. Kindly see. क्योंकि सब लोग का फोन आता है यार सर 5 करोड़ के ऊपर हो गया मेरा क्या मेरे ऊपर ये आ जाएगा अरेस्ट हो जाएगा क्या डे इन डे आउट यू आर कमिंग अक्रॉस. So 132 says punishment for certain offenses. Heading ही बोल रहा है punishment for certain offenses. Whoever commits or caused to commit or retain the benefit arising out of any of the following offenses. So committing of an offense is and arrest by a officer, central agency, which is provided, there it applies only in the case of clause A, B, C and D. 132(1) का A, B, C, D. आगे जो भी क्लॉजेस है उसके लिए एप्लीकेबल नहीं है. ओके, अप टू L तक है. उसमें 2 डिलीटेड है, 3 डिलीटेड है. Up to L it is there. So whoever, any taxable person who is falling under the parameter of this A, B, C, D, then only he can be arrested if he has made an offense. 1. So A क्या कह रहा है? Supply of goods or services are both without issuing invoice. So first है, if you are not issuing an invoice and supply of any goods or services in violation of the provisions of the act and rule made thereunder with an intentions to avoid tax. खाली simply supplying of goods services without invoices. If you are having a guilty conscious mens rea, that is with intentions to avoid tax. So subject is wherever a penal provision applies, intentions to avoid tax. So intentions to avoid tax, you are not issuing invoices, but supplying goods and services. Then in such circumstances, you are falling under clause A. इसका एनालिसिस बहुत बड़ा है, जब भी इसका कभी मौका मिलेगा तो एनालाइज करेंगे इसे. Under keeping in mind the criminal aspects, अपना IPC जो now listed. Issue of invoices are will without supply of goods again, but again that is also with an intentions to wrongful availment or utilization of ITC or refund of tax. Then third, availment of ITC using the invoice or bill referred to clause B fraudulently. Again, fraudulently. So intention to avoid tax, wrongful availment, then fraudulently avail ITC. Then fourth is collect any amount of any tax but fail to deposit. Their intention agar वगैरह कुछ नहीं. Please keep in mind their intention and everything is not there. Collect any amount tax, fail to pay the same to the government beyond a period of 3 months from the date which the payment is become due. Their intention agar वगैरह नहीं है. Please keep in mind wherever you are giving opinion to your client. Whoever collects and doesn't pay tax within 3 months, then he is falling under clause B. If it exceeds 5 crores, they have the power to arrest. But other than these 4 clauses, arrest is not possible. Even for these clauses, you don't have a mechanism of arrest in your own law. So you have to bend upon criminal procedure code or अभी जो आया है भारतीय is called CRPC न्याय सुख्य संस्था श्रुसख्या संस्था नो रिपील में जो सेविंग क्लॉज जनरल क्लॉज एक्ट विल ऑलवेज प्रिवेल लाए ना लाए सो कंटेक्स्ट है because constitution directs you to apply general clause wherever not there in any enactment. So वो context में वो ऐसा गलत हो जाएगा ऐसा. So in Radhika Agrawal says that so you have to apply the parameter. First, one, when an officer is exercising his power under this act, he has to sure in his mind that the person to whom he is going to arrest is committed an offense, first made an offense. How? With documentary evidence. So commissioner has to form an opinion first that committed offense. That's what the criminal law says. So committed an offense has to be established by way of record that yes, committed. Not only committed, with willful intention, with an intention to avoid tax. वो भी record पे लाना जरूरी है, that opinion. And that opinion which was drawn before arrest, it is to be handed over to the persons to whom you are going to arrest. ये सब फॉलो नहीं कर रहा, बुलाते हैं स्टेटमेंट लेते हैं अंदर बैठ जाओ, ऐसा ही हुआ इधर राधिका. So all these aspects you are needed to be followed. You have to hand it over that thing. And most important, और क्या बोले? Very important. Court has said. Under section 69, if you want to arrest for the cause of action arise under 138. Then क्या बोल रहे? Before placing a person under arrest, the legal requirement must be fulfilled. The reason to believe to arrive at a decision to place an alleged offense under arrest must be unambiguous and amply clear. And the reason to believe must be based on credible materials. Since arrest is on the taking away the personal liberty of an individual, the power to arrest must be exercised carefully. The arrest should not be included in a routine or mechanical manner. One of the legal ingredients of the offense are to be made out. Offense का जो legal requirement है, that is to be, what is offense? If you read offense, an act or omission made punishable by under any law for the time being in force. An act or omission made, an act should be with guilty conscience, with intention to avoid tax. It should spell from your that memo which you are giving to them, to whom you are arresting. Whether the person was concerned non-bailable offense or credible information, ये जो नॉन अवेलेबल कंसेंट से जो है A to D है, बट अगेन आगे बोले, देखिए ये सब चीज ध्यान रखना जरूरी है। इवन इफ यू हैव कमिटेड A to D, whether he can apply for bail, इधर भी नॉन अवेलेबल लिखा है। यस, हाउ? अंडर आर्टिकल 21 राइट ऑफ लिबर्टी जो है, लिबर्टी ऑफ हिज पर्सनल लिबर्टी, you can directly jump to the court by way of writ jurisdiction. So the writ court को भी सुप्रीम कोर्ट ने इन राधिका अग्रवाल डायरेक्ट दिए, in such circumstances you have to entertain these petitions wherever anticipate, wherever life and liberty of a person is under threat, there you have to take cognizance of all these aspects. So writ is like, कल हम बोलते हैं कि writ भी नहीं हो सकता है, ये नहीं, no, under article 21 anyone can come. So the Radhika wall, when कब करेंगे अरेस्ट? The memo should spell that he is liable to temper the course of further investigation. Investigations को hamper करेगा, temper करेगा. In such circumstances, you have to bring how he can temper. ये सब लिखित आकार में ओपिनियन ड्रॉन करके लाना पड़ेगा. Then only you can arrest. So, am I clear so far as this aspect is concerned? और कितना टाइम दे रहे हैं उमंग मुझे?
Sir, my suggestion was that if you want to take one case and then others. Don't curtail your discussion. Not at the cost of our getting knowledge.
हाँ, क्योंकि I was under impression that मुझे 1.5 घंटा 2 घंटा मिलेगा, एटलीस्ट मैंने इतना सिलेक्ट किया है, इसलिए कीपिंग इन माइंड.
But like first discussion was very good and very, so we cannot curtail discussion. If you have time, we can convene one more time.
Okay. Radhika Agrawal, I think
Yes.
ये suffice है. Any queries, sir? Obray ले लेंगे. Obray construction is the most important disk. Everybody casually, everyone जो भी कर रहा है बिजनेस, कुछ भी आया हमारे पास बोलते हैं सर रिट फाइल कर दो.
One question is there for Radhika.
Yes, yes, tell me. Yes,
Whether
please.
value tax invoice, where invoice is mandatory, would be considered as an intent to evade tax.
No, not at all. Not at all.
So because the act says that if you issue any other document other than an e-invoice, then it would not be considered as a valid.
That is a procedural part. Procedural part. It is not a substantive in nature. So as to not to with an intent to avoid tax also. क्या साहब क्या बोल रहे? अभी LNT को पीछे छोड़ दीजिए ना, अभी LNT गया है. Even a machinery provisions doesn't come in your way when a substantive provision is wrong. सबॉर्डिनेट है, उसको क्योर कर सकते हैं. वो उसके लिए और एक जजमेंट आया है ना सुप्रीम कोर्ट में, मैं वो सिलेक्ट किया है कि हाउ डायरेक्शंस कैन बी गिवन, आप रेक्टिफिकेशन कैसा कर सकते हैं. दैट लास्ट जजमेंट इज सुप्रीम कोर्ट डिसीजन व्हिच इज हाँ. So portal is subsidiary or secondary law. The last judgment is on that count. Somebody has applied for rectification. ये बोले कि rectifications की time limit चला गया, उसके अंदर वो upload नहीं हो पा रहा. Then matter went to Supreme Court. Supreme Court has gave guidelines how to cure such defects when a person is eligible for ITC. वो that last judgment जो भी आपने ये में. Obray construction. Obray construction. Everyone is running casually against the show cause notice, against the assessment order directly, without invoking the mechanisms which is availed under the law. GST law में जो भी mechanism है, show cause है तो reply दो. 2A अपना क्या बोलते हैं उसको, 2A मिला ना, DRC 01A मिला तो उसको reply दो. 707A क्या बोलते हैं, DRC 7 तक क्यों वेट कर रहे हैं? All mechanisms in between you apply it. Before 7 also the issue so cause notice, you reply it, claim. Here the issue was in Oberoi construction, municipality collects some charges. Now the claimant's contention is that Oberoi's, all these municipality and all these charges they are collecting as a public utility body which is falling under the Constitution 243W. And they are not subject matter of charge. In fact, it is an exempted because of some notifications. So cause notice officers is using purposely and with an intentions to charge me tax on that. So directly jump to High Court. In another matter, assessment order is also passed that has gone directly. Court said, how you are existing an alternate remedy? If you have an alternate remedy, go to that. Don't come directly to 226. For that purpose, Supreme Court has laid down guidelines in Walpole. Walpole's matter. I am giving the title. Walpole Corporation versus Register of Trademark. 8 SCC page 1, 1998. Walpole Corporation versus Register of Trademark 1998. 8 SCC page 1. In Walpole Corporation, when a writ petition will lie before any high court, they have clarified. Till date, all high courts and Supreme Court even following the same principles. When you can go directly to the high court, when your fundamental right is, as I pointed out, Article 21, right of personal liberty, arrest of threat is there, you are moving under Article 21. So fundamental right is breached. There you can directly go. Same industry, मुंबई यूनिवर्सिटी को एग्जाम्पशन दे रहा है, केरला यूनिवर्सिटी को नहीं दे रहा है. Discriminatory, Article 14. Directly go to High Court under writ judice or Supreme Court under 32. So, violation of fundamental right. 1. Where there is a violation of principle of natural justice, मैं सुनवाई नहीं करूंगा, टाइम ही नहीं दूंगा, आज नोटिस दिया, कल ऑर्डर पास करूंगा. Okay, violation of principle of natural justice. So you have to establish in your petition either fundamental right is violated or principle of natural justice is not there. But where the order or proceeding is wholly without jurisdiction, ये बहुत इंपॉर्टेंट है. wholly without jurisdiction. wholly without jurisdiction कैसा होती है? By way of notifications they are coming. 243W entry में clean clear लिखा है, urban development planning by SRA, by the municipality, by the local authority or any other person will fall under 243W. उसको वायोलेट करके आप कॉन्ट्ररी ऑर्डर पास कर रहे, तो कोर्ट इसमें क्या बोला? इन दिस ओबराय कंस्ट्रक्शन, यू प्रेजेंट ऑल दीज थिंग्स बिफोर योर अल्टरनेट रेमेडी में रखो ना. अगर वो नहीं सुनेगा बोल के आपको क्यों अपेरेंशन आ रहा है? हो सकता है वो सुनेगा और अलाउ भी करेगा. So wholly without jurisdiction or where the virus of the act itself is under question. जैसे हम पढ़े अभी वायरस की सेक्शन 7 में ये लैंग्वेज इज नॉट क्लियर, then you can go directly to 26. So except these 4 conditions, you cannot come to High Court directly. So Oberoi constructions restricted every day and doubt jumping to the High Courts. So keep in mind one pulls these 4 criteria, then decide whether to go to High Court or not. Clear? जब भी बोलेंगे मैं स्टॉप कर दूंगा, नहीं क्योंकि आपका मीटिंग है ना. Yes sir. Any questions on this? Then it is a without giving a natural justice is not followed. यही मैं बोल रहा हूँ, आपको एक दिन टाइम दिया, नहीं गया तो एक्सपर्टी डिसाइड कर। सो नॉन फॉलोइंग जो प्रिंसिपल ऑफ नेचुरल जस्टिस के जो पैरामीटर है बहुत सारे, इफ इट इज नॉट फॉलोड, no, see, once a service mechanism is found in the GST legislation, service कैसी होनी चाहिए? If you found in the GST legislation, if service mechanism is not followed, then in such circumstances it amounts to a violation of principle of nature. Lekin if it follows E mechanism, if it is also there, then also it is amounts to a service. So, वो principle of natural justice you cannot challenge that. So, a very broad concept principle of natural justice that is to be looked into fact to fact. Okay. गुजरात हाई कोर्ट डिसीजन ऑन लीज, राइट टू यूज, पहले भी आप सेशन लिए थे, 2 बार हुआ, मैंने 3 बार आर्टिकल छापा है उसके ऊपर। Another judgment, but it is elaborate. नहीं, in Gujarat High Court decision, the facts of the matter is that GIDC gives license or lease basis to various commercial industries to undertake their businesses. This is one aspect. For certain years, if a person doesn't want to carry the year granted, then he have every right to surrender or assign his lease right to any other third person. So in all these matters, assignments were made of what? Unutilized years, number of years, number 1. Number 2, to run the business effectively, the structures which has taken place on that land, building बनाए, way bridge बनाए, canal बनाए, pipelines बनाए, all these things plus the unutilized portions assignment is given. So the question now comes whether it is subject matter of levy of tax under the GST law. So for analysis, there are 2 entries are there. मैं एक बहुत सारे फार्मूला बनाया, जब भी मुझे मौका मिलेगा, आज बात ही कर रहा था मैंने छेड़ा साहब से. So how to read a GST law, simple way में, how to read and how to understand, उसके ऊपर कुछ कर रहा हूँ रिसर्च, वो आएगा तो फिर शॉर्ट पब्लिकेशन भी कर लेंगे यार, इंक्लूडिंग क्लासिफिकेशंस का ऊपर जो भी, वो दोनों करेंगे. सो दिस एनालिसिस में आप देखेंगे, फर्स्ट इज यू आर चार्जिंग सेक्शन 9, सप्लाई ऑफ गुड्स और सर्विसेज, और बोथ 1. It should fall within the ambit of scope of supply 7. This scope of supply exhaustively elaborated or explained in 3 schedules. Schedule 1, Schedule 2, Schedule 3. Schedule 1 says, although you are not falling under section 9, but that will fall within the parameter of Schedule 1. The consideration होना जरूरी है ना under the scope of supply. So in Schedule 1, Schedule 2, entry 5, we are concerned with entry 5. Entry 5 speaks about lease or license, granting of lease or granting of right to use. भले by way of exemption notification clause that residence is exempted, वो छोड़ो, commercials. Second is construction activity, sale or supply of flat building or commercial apartment, वो जो सब है वो उसका next clause में. Then Schedule 3, the title itself says it is not, it will not fall under the parameter of scope of supply at all. So section 7 में ही डाल दिए कि you are not coming under the parameter of the scope of supply, Schedule 3. Schedule 3, one of the entry, what it says, sale of land or building, except entry 5. 5A, B. बराबर? B, 5B, except 5B. Now the question arises, sale of land or building. Assignment of this lease right given to a third persons by the lessee, whether tantamount to sale of land or building, so as to not to fall under the parameter of scope of supply. ये question है. At the cost of repetition. Assignment of the unutilized right along with the structure and building given to a third person with the consent of the owner, GIDC. If it is given, then in such circumstances, whether tantamount to sale of land or building or not. This question came up before Gujarat. Gujarat High Court had said, have you defined sale of land, sale of a building in your own act? If answer is no, if you have not defined, then shelter is to be taken from other enactments which governs the body, this type of situations. So take shelter of Transfer of Property Act, Indian Registration Act, General Clause Act. Take shelter of all these and take the meaning. What do you mean by sale of land or building? There are a number of judgments are there. Right from Privy Councils is there, but one of the finest example I will give to elaborate these aspects, which has they considered also, and you will find in my articles also, earlier in the latest article also on this issue. In Orissa, I am from Odisha. In Orissa, इसको हिंदी में बोलता हूँ, बहुत अच्छा लगेगा. मच्छी पकड़ने के लिए कुछ लीज होल्ड राइट देते हैं तालाब की, फिशिंग ले. तो एक पर्टिकुलर आनंद बेहरा, one man is known as Anand Behra. He acquires that right. कुछ 10 years, 15 years के लिए लिया है राइट. जैसे ये मानसून जाता है, देन आफ्टर विंटर जाता है, धूप आ जाता है, पानी सूख जाता है. पानी सूखने के बाद क्या करते हैं, सब लोग चलना करते हैं, कोई क्रिकेट खेलते हैं, कोई बैल चराते हैं, कोई गाय चराते हैं, सब कुछ करते हैं. He filed a criminal complaint against those who are utilizing that one. तो बोले this is under lease for this lease of water and land for 15 years. आप लोग इसमें एंटर कर नहीं पाएंगे. Then he come with an ये situation जो fish है, I am carrying fish, I am taking fish out of that pond. ये fish की जो अंडा है वो डिस्ट्रॉय होता है. जो अंडा देते हैं सूखा रहता है, जैसे बारिश गिरेगा वो मच्छी बनती है. सो वो स्पॉइल हो जाता है. सो दिस राइट जो है टू कैरी द फिश और टू प्रोटेक्ट दैट फिश, ये जो राइट मैंने लिया ये लीज में, attached to this immovable property, therefore it is an immovable property, therefore it is a land, and hence I am obstructing you. This matter went to Supreme Court. Supreme Court said yes. Any benefit accrued or arised out of that land amounts to. कल उठ के रत्नागिरी में आम का खेती बगीचा है, बहुत बड़ा है. एवरी ईयर एक आदमी ने लेता है 15 साल के लिए लीज. किसी ने दूर से थोड़ा वो खेती को लग के आग जलाया, सो दैट उसकी जो सब फूल आया हुआ है वो जल जाए. सो वेदर ही कैन टेक, ये जो तुम्हारे कॉज की वजह से मैं बेनिफिट एक्रूड और अराइजिंग आउट ऑफ दिस लैंड इज ऑब्स्ट्रक्टिंग, सो दिस सिचुएशंस कम्स. सो एनी बेनिफिट accrued or arising out of land, though out of the leasehold rights, Supreme Court in canton of judgments has hold that this benefit arising or accruing out of this land is nothing but it is a part of immovable property and immovable. Therefore, ये जजमेंट का बाद खत्म हो गया. immovable property and immovable properties. Now question again उठाते हैं, ये immovable property है, ठीक है. Language in schedule 3 क्या है? Sale of land or building है. So what do you mean by sale of land then? So benefit arising or accruing out of land is also a land. So immovable property includes land. Okay. So although Supreme Court has analyzed it in the context of immovable property, sale of land means sale of benefit accrued arising out of that land is also a sale of land. इसलिए इवन लीज होल्ड प्रॉपर्टी में 1/3 डिडक्शन इसलिए आप दे रहा है ना भाई, कोई भी राइट में वो प्रॉपर्टी होने दो, उसमें बिल्डिंग कंस्ट्रक्शन करते हैं, 1/3 डिडक्शन दो. व्हाट डू यू मीन बाय दैट? वेदर इट इज ए एक्चुअल कन्वेंस मेड के लैंड को पार्टीशन हो रहा है सबके अंदर, और एनी बेनिफिट अराइजिंग आउट ऑफ दैट लैंड, लीज होल्ड प्रॉपर्टी है 99 ईयर्स की. तो देन इन सब सर्कमस्टेंसेस क्या होगा? और उसके ऊपर बिल्डिंग खड़ा कर दिए तो आपको 1/3 डिडक्शन नहीं मिलेगा, लैंड नहीं है बोल, उसे बेनिफिट accruing arising out of that land है. So in that context they have interpreted and hold that any benefit accruing or arising out of the land also equated with the land or building. So इसमें जो GIDC, undoubtedly you know, GIDC when grants the lease, टैक्स नहीं है फिर भी लोग टैक्स भर रहे हैं, क्यों भर रहे हैं पता नहीं. One exemption notification is there already. Above 30 years ago, any lease is granted by the state government, central government, or any authorities under the central or state government, those who are, वो define हुआ है, government and authorities under the government, public authorities. So there, no tax is leviable. So the original, whether it is called salami, premium, whatever name may be, ऐसा लिखा है language in that notification. So if it is granted by the SIDCO or MADHA or GIDC and taking the premium or salami or whatever name called, no tax is applicable, फिर भी लोग भर रहे हैं, वो कलेक्ट भी कर रहे हैं, भर रहे हैं. वो apart from that, वो तो नहीं है. Benefit accruing or arising out of that land is also not subject matter of levy. Gujarat High Court clearly hold this situation, and Bombay High Court in some of the matter prima facie accepting it. See, it is a matter of interpretation. Again, I am repeating. First judgment. Constitutional validity is ultra vires is not under challenge. It's a matter of interpretation. So in such circumstances, it is having a persuasive value only. Binding nature नहीं है. मैं repeat कर रहा हूँ. Again, wherever ultra vires or constitutional mechanism is there, then that's why everybody has jumped to our own high. Okay, having a persuasive value to make uniformity, we may accept it. Okay, that's a different part. ये लाइट पे ये की. So I think this is GIDC क्योंकि आपके ऊपर फुल सेशन हुआ था इससे. प्रेसिडेंट साहब, अभी मीटिंग है ना आपकी?
Last budget, the indexation was removed.
Indexation?
Indexation of category was removed. It's finance budget. So then after a lot of representation, they reintroduced for resident for land and business.
हाँ.
Whether that
Same meaning. Yeah.
whether we can take that.
I took a house in Chembur area, which is under 99 years of lease. Okay, I took. So there I applied all these formula of section 45 का जो capital gain की scheme की है, transfer की जो concept है, this applies equally from the beginning. Even Registration Act speaks about that. Transfer, because the word transfer. So sale is nothing but it is one kind of transfer they have imported from, because you have no definition under the GST law. You have not saying transfer, you are saying sale. So transfer is a broader concept. Sale is one of that. So sale is also one of the kind of transfer. In that way, they have been. ये दो ही अभी कर लेते हैं ना, बस ज्यादा नहीं है, छोटा छोटा ही है दो. Srinivas Railcon, the issue is about, kindly see, very interesting. TDR and see, a society is there. A society has transferred his right to a builder, asking them to construct a new building and give the buildings. So, price वगैरह सब fix हुआ. Officer has demanded, बोलते हैं on reverse charge you pay tax on because you have received TDR, you have received FSI. So TDR and FSI once received, then on reverse charge basis you have to pay tax by the builder. Builder said, I have not received any TDR or FSI. What I have received in the agreement to develop that particular plot in the form of a FSI which is accrued or arised in that area, in that building. So you cannot equate it. So what I am doing, under an agreement, I am developing a building, and when I have not purchased any TDR or FSI from the open market. And under this agreement, I am developing this particular plot. I have not purchased TDR and FSI. So you cannot equate with that. Therefore, they hold that. I mean, our own High Court Nagpur held that. Read the agreement. The minute reading of simple reading of the agreement shows he is a developer developing. When he will sell the plot, then the rule will apply accordingly. So he is not buying any TDR or FSI. Therefore, they have struck down. Okay. Now next, another judgment of our Bombay High Court only in the matter of कौन सा है ये? In this case, petitioner क्या कर रहा है? Exhibition purpose के लिए foreign territory को भेज रहा है diamonds. Okay. So when the custom authority has cleared, they treated that it is an export in their own portal and everything and collected tax out. Then जब ये exhibition खत्म हो गया, re-import हुआ. Now in this re-import, again they are saying that you have to pay tax on that. He said that I have exported it, I am entitled refund. आप क्या अलग से मांग रहे हैं? You have no coordination with the state authorities and central authority. You see, he has brought evidences, everything, but was not granted. So court has held that you should have a coordination with your authority. They are treating it as a export, paying tax on that transactions. Even IGST has paid. In fact, he is entitled to refund on that. How you are saying that it is an important leviable, but tax is leviable? In that context, this judgment has decided. Last, but not least, another judgment, Supreme Court. Here, only two-page judgment, but interestingly, Union of India versus Bridge System Limited. A mistake, I am reading. It appears that on account of a mistake or error, getting noticed on the input tax credit and the input tax credit being subsequently denied to the purchaser, the revenue has been taking the stand that rectification is not possible after expiry of the period prescribed in the CGST Act. In order to resolve the issue, we deem it appropriate to issue the notice to the Central Board of Indirect Tax and Customs. Matlab, such sort of mistake if arises, you allow the party to cure that defect wherever he is eligible to claim the benefits. On that basis, they have done. I think sab le liye dhire dhire. Okay, thank you. Thank you.
Again, complete.
Thank you, sir. So friends, you all will agree that in a short span of 1.5 hours, sir has taken us through all the decisions and it was so in depth. Sir has explained to us that though we are aware about all these decisions, but it was wonderful insights what we came to know through this session. So, sir, we are really thankful for your session and it was really helpful that we came to know many more things about these decisions. So, we are very much thankful and we are looking out for many more sessions from you, sir. So with this, I am thankful to today's speaker, Ratan Samal ji. I also thankful to all the dignitaries of the dais and those who are attending online. So there are so many participants who have participated online as well. There are 80 plus online participants as well. And here also there are a lot of participants. So we can understand that how deeply sir has explained all these decisions. So thank you once again. Yes, and of course there are past presidents also available. So we are thankful to all the past presidents as well. Thank you, sir. Yes, yes. If there are so many past presidents, so we are thankful to all of you. So with this, now there are one more announcement I would like to make. We are in the beginning of the new financial year. So those who have not renewed their membership, I request you all to renew your membership. Or if you want, you can also go for the life membership. Even we have started with the student membership as well. So you can enroll for the same and you will get many more such sessions to attend being a member of the GSTPM. So thank you. Thank you so much for your attention. Thank you. With this, now I request you all to please rise for the national anthem. Jana Gana Mana Adhika, Jaya He Bharat Bhagya Vidhata, Punjab Sindh Gujarat Maratha, Hind Himachal Yamuna Ujjala Jaladhi Taranga, Tava Shubha Naame Jage, Tava Shubha Ashish Mage, Gaye Tava Jai, Jana Gana Mangalaya, Jaya भारत माता